You bring a lawsuit against your careless doctor claiming that he caused you significant harm and injury. During the course of your lawsuit, the defense tries to throw your case out, claiming that you don't have a valid basis for a case. In response, you turn around and say, hey, Mr. Oginski, I want you to hire 5 different experts to oppose the defense's request to throw out this case. Do I do it? Do I hire 5 different experts? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a beautiful day today here in Great Neck, and I wanted to share this really useful information with you to help you understand how these types of cases work here in New York. Okay, so you decided to bring a lawsuit against your careless doctor claiming that you suffered significant harm and injury. A medical expert has reviewed all your records and confirms that you have a good valid basis for a case. Now we proceed forward. During the course of your lawsuit, the defense turns around and says, this is nonsense. We don't believe you have a valid basis for a case at all. So now they ask the judge formally in writing, that's known as a motion for summary judgment, to dismiss and throw out your case before you ever get to trial. Guess what? Can they do that? The answer is yes, they can. Now I tell you that we have to respond and put in reply papers to oppose the defense's request to throw your case out. And I tell you that we have an expert who reviewed your records at the very beginning. When I tell you that I have to put in papers to oppose the defense's request to throw your case out, I tell you that we have a medical expert to support our particular case. And you turn around and say, wait a second, I don't want to just rely on one expert. I want you to get 2 experts. No, better yet, get 3. Better yet, get 4. Oh, best of all, get 5 medical experts to go up against their 1 expert. So now it's clear that we have 5 experts against their 1. You know what I say to that? That's not happening. You know why? For a couple of reasons. The first reason is that the judge will not consider 5 experts all saying the same exact thing. They won't do it, especially if they're all in the same specialty. So let's say they're all surgeons, right? It would be ridiculous for me to get 5 different surgeons, pay 5 different experts to review all of your records, and come to the same conclusion. 5 different experts all saying the same thing? The court would call that cumulative testimony or cumulative evidence. It all says the same exact thing. The mere fact that now I've gotten 2 experts to say it, or 3, or 4, or 5, doesn't lend any greater credibility compared to the 1 expert that the defense has brought in to show that we don't have a good case. What will happen is that when we bring in our expert to prepare papers to say, listen, here's why we have a good basis for a case, the defense has already put together papers for their expert who says, listen, I've gone through all the records and I feel that there is no valid basis for a case. So now what does the judge do when you've got 1 expert who says one thing, that there is a case, and you've got 1 expert who says, no, there isn't a case? Well, now you've got competing interests here. You've got competing experts. And then the question becomes, okay, who's the better expert? Who's got better credentials? Which expert do I give more weight to based upon his evaluation, based upon his experience and his credentials? And you know what? In that instance, the judge is not going to get involved and make a decision right then and there. At that point, the judge is going to turn around and say, listen, this is no longer a legal issue. This is a factual issue. And I'm not here to decide factual issues during this motion for summary judgment to dismiss the injured patient's case. Instead, I'm going to let the jury decide this issue when it gets to trial. So I'm going to deny the defense's request because there are issues of fact to be decided in this particular case. This is not a situation that only has an issue of law to be decided. In that instance, the judge says, defense lawyer, no, you are not getting your motion, you are not getting your request to throw out this case at this time. So this case is continuing forward, and now I'll see you guys at the time of trial. And ultimately, the jury will be the ones to determine which experts they believe. Do they believe our expert? Do they believe the defense's expert? But why do I share this information with you? I share this with you because this does happen from time to time, where now the defense asks to throw out your case. We now have to put in papers to oppose the defense's request to throw your case out. And the injured patient turns around and says, listen, get as many experts as you can. Let's stack it so that now the judge will have no choice but to realize we have a good case. You know, I realize you're likely watching this video because you're enjoying the scenery like I am. No, I realize you're watching it because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.